Phrases like individual self-fulfillment and individual self-realization reflect the idea that individuals should have autonomy over a certain realm of activities that the state cannot regulate, and that the realm of individual autonomy should include speech and expression. It's important to note that the political speech theory, better than the theory of individual self-fulfillment, fits the cases. Important to note, and here I'm being descriptive only, important to note that the actual cases decided by the Supreme Court line up better with the political speech theory than they do with the idea that the First Amendment protects individual self-fulfillment or realization. I guess the best example is the law of obscenity. From the point of view of democratic self-government, from the point of view of maintaining popular sovereignty, hardcore obscenity is close to valueless. Hardcore obscenity does not contribute much to political debate. It doesn't help us decide whom to elect or what policies to pursue. From the systemic point of view, obscenity, as distinct from debate about obscenity, but the obscenity itself is peripheral, borderline, marginal speech, and therefore of low First Amendment value from the point of view of political decision-making. But from the point of view of individual self-fulfillment or individual self-realization, obscenity would be high-value speech. If one views the First Amendment as primarily defining a sphere of individual autonomy, of individual choice, then matters of sexual expression would seem central to that idea. So one way of looking at the exclusion of obscenity from the law of the First Amendment is that it reflects the Supreme Court's judgment, a judgment, of course, that you may find controversial. But it reflects the Supreme Court's judgment over the years that political speech is a more important rationale than individual self-fulfillment for protecting free speech. Now, I have not said nearly enough about this or the other exclusions from the First Amendment to provide a firm foundation for a choice of one First Amendment theory or another. It's not my objective to encourage you to make a choice between one theory and another. My point is only to illustrate the connection between specific First Amendment issues and overall First Amendment theories. Here is the point. In order to write the best examination possible in freedoms of speech and press, you must relate the specific issues to general theories of the First Amendment, whether political speech or individual self-realization or something else. That's the conclusion. Let me state it for you again. It is the key point. In order to write the best examination possible in free speech, you must relate the specific issue to general theories of the First Amendment, including the political speech principle, individual self-realization, and perhaps others that your professor may have covered. The First Amendment not only contains guarantees of freedoms of speech and press, it also contains clauses protecting the free exercise of religion and prohibiting the establishment of religion. First, free exercise. The free exercise clause protects religious belief absolutely. You are absolutely entitled to any religious belief, no matter if it seems wacky or reprehensible to the rest of us. The fighting question, does the free exercise clause also protect religious conduct? Answer, yes, in a sense. Conduct cannot be prohibited because it's religious. That is, no government could pass a law suppressing religious conduct for that reason. A statute of that sort would be struck down in a heartbeat. Of course, we virtually never see laws of that sort in this country. For the past 20 years or more, the crucial issue in free exercise law has been accommodation. Must the government grant exemptions from generally applicable statutes in order to accommodate religious belief? That's what we call accommodation. Must the government grant exemptions from otherwise valid statutes in order to accommodate individual religious belief? Basically, accommodation claims boil down to claims of special treatment. Religious individuals say, yes, I understand that this law is valid generally. I understand that you can enforce this statute against everyone else, but you can't enforce it against me because I'm religious, and this statute contradicts my religious beliefs. Therefore, I get an exemption from the law, or, if you prefer the phrase, special treatment because of religious conviction. Such claims were never routinely successful, but some of them were. The most famous example of an accommodation case, one that I suspect you've read, Wisconsin versus Yoder. All children were required by statute to attend school through a certain age, except the children of Old Order Amish, who objected to the mandatory school attendance law on the grounds that it would impair their religious community and violate their religious beliefs. And the Supreme Court said, yes, the Amish get special treatment. They get an exemption from the school attendance law that applied to everyone else. They get a constitutionally required accommodation of religious belief. As I mentioned, Wisconsin versus Yoder is a prominent case, but perhaps exceptional in that many other such claims were rejected. In 1990, the Supreme Court signaled an apparent end to accommodation. The case decided in 1990, a case that most of you will have read, Employment Division of Oregon, Human Resources versus Smith. The Smith case upheld a statute against hallucinogens. The statute included peyote, an hallucinogen used by Native Americans as part of a religious ritual. The Native Americans claimed that because they used peyote as a religious ritual, that they were exempt from the statutes governing everyone else. The Supreme Court said no. And in Smith, the Supreme Court said that in general, if the government has a valid reason to regulate conduct, everyone can be made to obey the law, whether they have religious objections or not. That's the holding of Smith. If the government has a valid reason to regulate conduct, legitimate reason to regulate conduct, such as the use of hallucinogens or attendance at school, everyone can be made to obey the law, whether they have religious objections or not. Now, the Smith case excited a good deal of adverse comment and hostile reaction. In 1993, Congress overturned the Smith decision by statute. Statute is called the Religious Freedom Restoration Act, or RFRA. That statute declares that the government, here I'm quoting, shall not substantially burden a person's exercise of religion even if the burden results from a rule of general applicability. That's the statute's message. It shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability. A substantial burden on religious exercise required a compelling government interest. Now, it's very important that you see clearly what this statute, the Religious Freedom Restoration Act, did and did not purport to do. The statute did not overrule Smith as a matter of constitutional law. Congress can't do that. Marbury versus Madison says at least that Congress cannot override a Supreme Court interpretation of the Constitution. What the statute purported to do was not to overrule Smith as a matter of constitutional law. What the statute purported to do was to give religious believers rights additional to those guaranteed under the Constitution. In other words, the Religious Freedom Restoration Act was like any other civil rights statute. It protected as a matter of legislative judgment various freedoms that the Constitution itself does not guarantee. In 1997, the Supreme Court struck down the Religious Freedom Restoration Act as being beyond federal legislative authority. Again, it's very important to focus carefully on what the court said in that case. The Supreme Court said, no problem in requiring federal government accommodation of religious belief. The United States Congress has undoubted authority to control the conduct of the federal government. And if the United States Congress wants to say that every religious believer gets special treatment absent a compelling government interest, they can do that insofar as they're regulating the conduct of the national government. But, as you heard in Lecture 2 on federal legislative power, the Supreme Court found that Congress lacked authority to pass such a law for state and local governments. Now you see, this is not a question of Congress violating individual rights. Indeed, Congress was expanding individual rights. It's a question of Congress legislating beyond its power. So, under the Supreme Court decision, states could, if they chose, accommodate religious belief, but the national government cannot force states to accommodate religious belief. Why? Because that's beyond federal legislative power. In essence, it was a problem of federalism. The other religion clause in the Constitution prohibits the establishment of religion. The Establishment Clause is an embarrassment to all constitutional law scholars. There is simply no area in this entire subject more confusing than the Establishment Clause. It's an intellectual train wreck with different cases going off in different directions at different times. Very hard to have a clear understanding of an area where the Supreme Court has been so confused and confusing. For many years, the Supreme Court talked about a three-part test. Now, the headline is that the three-part test was never very satisfactory. It was never very descriptive or predictive of results. But that was what the Supreme Court said, so here it is. First, does the law have a non-religious purpose? Does the law have a non-religious purpose? Second, does it have the effect of advancing religion? Does the law have the effect of advancing religion? Third, does it produce excessive government entanglement with religion? excessive government entanglement religion. Now, these are the three parts of the test. One of the problems with the three-part test is that there was always tension between its components. Think for a moment about the perennial problem of government aid to children who attend religious schools. Now, if the government simply gives money to religious schools or to the students who attend them, the risk is that that money will be found to have the effect of advancing religion. Right? If the government simply says any student who wishes to can attend a Catholic parochial school and will pay the bill, the risk is that some court will find that that money is advancing religion because it is used to fund education in a religious institution. So the government would try to avoid that problem by specifying how the money can be spent. The government would simply place a number of restrictions and regulations. We will fund X and not Y. We will fund sports and not chapel. We will fund science labs and not discussions of human values. Whatever restrictions might be imagined, they would be designed to keep government money from having the effect of advancing religion. Now what the problem is, entanglement comes to the fore. Now the critics say, well, these regulations require that the government become deeply involved in the religious institutions administration, and that is an excessive government entanglement with religion. So the three-part test had components that were in tension, and to some extent the three-part test ended up saying you're damned if you do and damned if you don't. Damned if you give government money without restrictions, that has the effect of advancing religion. Damned if you give government money with restrictions, as that has the effect of excessive government entanglement. The effect is to foster separation of church and state. The Constitution itself does not use the word separation. But ever since Justice Hugo Black referred to a wall of separation between church and state, many people have thought that the Establishment Clause required a kind of mutual disengagement, a complete separation of church and state. And that was the tendency of the three-part test. Here's a great example of the three-part test and the wall of separation idea. This is a case from 1985. In that year, the Supreme Court held that it was unconstitutional to send public school employees into religious schools to give non-religious instruction on remedial subjects. I'll give you the facts again. Unconstitutional, said the Supreme Court in 1985, to send public school employees into religious schools to give non-religious instruction on remedial subjects. The court said that if the public school teachers were not carefully controlled, they might slip into supporting religion, which would violate the effect of advancing religion test. If the public school teachers were carefully controlled, there would be an excessive government entanglement with religion. Either way, the plan was dead. The effect to require separation of church and state. In 1997, the Supreme Court overturned that decision by a vote of 5-4. Now, in 1997, the Supreme Court purported still to be applying the same old three-part test. But it applied that test very differently and reached the opposite result. Today, the court has backed off requiring separation of church and state. Today, the court seems focused on government neutrality with respect to religion. I think that's a crucial concept in the most recent Establishment Clause cases. Less emphasis on separation of church and state more emphasis on government neutrality with respect to religion. Now, no doubt neutrality is hard to specify in some context, but it plainly does not require the complete disengagement between government and religion that some older cases thought necessary. Well, obviously, 1 hour of lecture cannot cover the whole First Amendment. Indeed, even a 3-credit course cannot do so. But if you had an introduction to the First Amendment as part of your basic con law course, this lecture should help you remember the essentials and prepare for the examination. We come now to the end of these 5 lectures on con law. Not every hour will be equally relevant to every one of you, but we hope that these lectures will help you in preparing for your exam and enable you to write the best possible answer in con law. Thank you very much for listening, and good luck on your exam.